Good afternoon, everyone. My name is Michelle Washko, and I'm the Program Director for BioStrategy Partners. And I'd like to welcome you today to the fifth in the series for 2020 of BioStrategy Partners Practical Knowledge Series. The goal of this series, one of the seminal programs for BioStrategy Partners, is to help educate the technology transfer, entrepreneurial, and academic communities about areas of interest as technologies are spun out of the university setting. We have a great panel for you today, but I'm not going to introduce them. I'm going to allow them to tell you about themselves. The topic is intellectual property for life sciences enterprises, expert perspectives. A little bit more about BioStrategy Partners. We are a not-for-profit organization. We're about 12 years old, and the intent is to stimulate technology development and spin-outs in the life sciences to encourage them through two seminal programs, one of them being, of course, Practical Knowledge Series, the second one being our Germinator program, which is designed to stimulate industry academic partnerships. And you can learn more about that on our website. So today's topic, again, intellectual property for life sciences. You can see your panelists here, Joe Murphy, Zev Sunleaf, and Scott Slomowitz. And before we get started, I'd like, as always, to thank our sponsors, MVM Associates, Césaire Rivise, we have two representatives on the panel with us today, and University Place Associates. And with that, I'm going to turn it over to our participating moderator, Joe Murphy.
Again, my name is Joe Murphy. I'm a partner at the law firm of Césaire Rivise. I've been there about 15 years. Before that, I was an examiner at the Patent Office for 6 years. I have a PhD in physiology from the University of Virginia, and my biology degree is actually from St. Joe's, so I'm local. My practice, really, I do a lot of patent prosecution, obviously, about probably 65%. The balance is a lot of opinion work. I do some litigation support in the sense of doing notice for generic ANDA litigation, things like that. So we're looking forward to today. I think it's going to be a great session. Scott, do you want to go next? Or?
Sure. So my name is Scott Slomowitz. I'm a patent attorney also at Césaire Rivise and I've had about 28 years of IP experience in IP law. My background is electrical. I have an electrical engineering degree from the University of Delaware. So my background, electrical systems, devices, computers, mechanical systems, processes, everything but chemical and bio, which is Joe's bailiwick. I work with a range of clients from large companies to small inventors and counseling them in all areas of technical aspects. I hold several patents myself. My practice is nearly 95% patent prosecution with 5% opinion work, where I also, I work directly with inventors on preparing patent applications and prosecuting it through the patent office. And before I became a patent attorney, I was a flight controls engineer at Boeing Helicopters, worked on an Army research program and an all fly-by-light Black Hawk helicopter. And then I also worked on the V-22 tilt rotor program. So that's my background.
Zev, you want to let us know? Thanks.
Sure. My name is Zev Sunleaf. I'm the VP of Tech Transfer, Innovation, and Research Contracts at Children's Hospital of Philadelphia. Been there about 3.5 years. Before that, I was involved in tech transfer at the University of Iowa for 15 years, director of that office for the last 5 or 6. And before that, I had spun 2 companies out of university technology and ran those for about 9 years. Academically, background is strictly on the business side, so more of a transaction person than a technical.
Oh, great. So I thought we'd start out today. We can maybe do a little discussion. Sorry, I apologize to everyone. I'm on my phone. I thought my computer was going to be up to the task today, but apparently it wasn't, so I'm on my iPhone. I thought we'd do a little background discussion about IP generally, and then we'll get into some more topics. So I guess if we want to talk, so we'll discuss everything. So I think, just to set a background here, we'll start with patents. What's a patent? What are trademarks, trade secrets, and copyrights, just generally speaking. So, a patent is really a government grant of something like a monopoly to an inventor. And it's a quid pro quo, as they say. There's a requirement that you have to give to the patent office and the public, something in order to get that monopoly, which is limited and limited in time. And so the things you have to do, and I usually explain these to clients as hurdles you have to overcome. One is you have your claims, what your right is going to be, your right to exclude others is going to be, has to be directed to patentable subject matter. And actually later on, we're going to be discussing that in quite a bit of detail. And then you have to have an enabling disclosure. So that means you have to describe to one of skill in the art how to make and use the claimed invention. You have to have a written description of your invention to show one of skill in the art you actually had possession of what you're claiming. And then you have to meet the formal requirements about definiteness and things like that in the claim set, as well as you have to overcome it's got to be novel, so there can't be one reference out there that would anticipate it, and it has to be not obvious. That means, an examiner or someone who was trying to knock down your patent couldn't combine two or more references to knock it out. So I think a few of those, particularly today, we're going to be talking about, I think we're going to come across patentable subject matter, and then also written description is going to come up a bit later on. And then if, I don't know if Zev or Scott, if you want to talk about maybe trademarks next.
Zev, did you want to say?
So I will. The one thing I will say about trademarks is, from an academic perspective, it's not something we work with a whole lot. As I've always joked, academics tend to have control of all the intellectual property at their institution, except for the trademarks, and those are usually tied to their football or basketball teams, and those are licensed by an entirely different group, including the Gatorade. But trademarks are something that don't usually fall into the tech transfer realm. They're usually tied more to the institution as a whole, and don't go through our office.
Well, I'll pick up where Zev left off. I mean, trademarks typically are names, symbols, or slogans that identify the source of goods or services. And through any of those, you want to be able to, you're trying to let the public know that when they see that trademark or service mark, they'll know who's providing these goods, and that the quality behind that is what the customer expects or can rely on. So it's basically protecting the label for that particular goods or services. So you're basically just associating a name, symbol, or slogan with the source of those with those goods or services, and those can be protected forever as long as you continue to use the mark in interstate commerce for the goods that you register them under. You can continue to use the mark. Now you can register the mark, or the use of the mark is good enough, but there are certain rights and advantages to registering the mark, because it gives you national protection. Whereas if you don't register it, you won't have the national protection that you would get with a registration. So the key with trademarks is the use of the mark in interstate commerce.
Great. So I think that's excellent. And the next one I want to cover, I think, is trade secret. Now, trade secrets are interesting, and I think we may have some interesting thoughts about this to discuss. So a trade secret is something that has to derive economic value from not being generally known. That's one part of it. And the second part of it is that whoever owns a trade secret has to take steps to keep it reasonably secret. Now, this is often in tension with a patent application. We'll say patent application or applying for a patent or getting a patent. So a trade secret is a way that if you've got I think, and other people may have other thoughts, I think of a trade secret often in the context of a process, particularly a proprietary process that you don't necessarily want to disclose to the public. You don't want anyone else to take what you've disclosed and sort of run with it a little bit, or even let them have any knowledge about what the quote secret sauce is to your process. So you're going to keep that proprietary. There's some weaknesses with it, though. A lot of times, the only people you can really enforce the trade secret against are former employees. So, people who you bring on your employees, they learn the process, they learn your customer list, whatever the secret you're trying to keep a trade secret, and then so that's who you end up suing quite often. Now, that said, I don't know, Zev or Scott, if you have thoughts on this, maybe about how that plays in the role of, say, a university context. Is there roles for trade secrets in university context in your experience, and what do you think about that?
There can be. We have had various researchers talk about the fact that they'd rather keep something as a trade secret than to put it in a patent application because they think it's probably not protectable from a patent standpoint and would rather not have competition. The one thing we do counsel them on is, to your point about who usually gets sued, is you want to make sure that very few people in your lab know that trade secret, particularly people who want to publish. Publishing is sort of antithetical to the entire concept. So keeping it very close-knit group, but it should not be part of something for which you're going to hope to use it to get grants, publications, and promotion, because that's just not going to work. So it's a decision you have to make very early on, not only from a publication and patenting standpoint, but from a who is going to work on that in your lab or your small company, because to your point, it's likely your grad students, postdocs, or employees who you're going to want to sue later because they either didn't know or didn't understand what a trade secret was. So they can be used in academia, but it's no one's top choice because it's just, we are so geared to the publication, presentation, and promotion track.
And another thing to add with trademarks is one of the things that a good advice for trademarks is the different trademarks should be inventoried, and an updated list should always be kept of that if it ever has to be enforced, so that the organization knows what it considers trademarks. Because if it does go to litigation, courts will look to see how you've treated these things once you assert something is a trade secret, and they're going to want to see all the precautions you take. So you should really keep a list of trade secrets from the start, what you believe are trade secrets, and make sure you're updating that, frequently or going over it.
I think
it's a locked, secret place.
Correct, right.
Put it in a secret place.
One other final thought on trade secrets, because we're probably going to jump more into the patent area in depth here, but trade secrets are often good if you think it's something that would not necessarily fly past an examiner. And I'll give an example. If you've got a process where it's got a very narrow temperature range at which the process is the best, works the best, that's something you don't necessarily want to tip your competitors to, because then they'll know what the best temperature range is. That's one. And two, it's very difficult to get a claim like that, a process, and it hangs, it twists on the novelty of or the narrowness of the temperature. The examiner's always going to say, oh, well, that's just routine optimization, and you can throw all kinds of evidence of non-obviousness at them, and a lot of times they're just not going to buy it. So that's another thing to consider. Sometimes the trade secret can be so narrow that it's critical, but it can be hard to convince the examiner that it's critical. So that may be something else to think about.
The other thing with processes that we found is if the product can be made using a variety of processes, proving which process they actually use from a patent perspective can be difficult.
Right.
So you may have an issued patent, but actually proving that it was infringed may be difficult if that's not the only way to make that final product. If it's really a process. So keeping that as a trade secret can be valuable because it gives you a competitive edge. Not something where you can keep someone from getting to the market, but you could possibly do it faster or cheaper by not disclosing it because it's hard to enforce.
Right. I'll jump in here, and if anybody who jumps on the call can mute their camera, that'd be great, if that's the right terminology. So I guess the last one's copyright. I don't think we're going to go heavily into copyright today, but that just applies to original works of art in all forms of media. I think, that goes beyond the scope a little bit what we're talking about today, but I just wanted to bring it up, unless Zev or Scott has any particular thoughts on copyright. I have a lot of thoughts on copyright. It comes up a lot in software. And one thing to consider and I warn clients about this, if you're going to be writing software and you're going to be pulling code down off the web, you have to be careful, because a lot of times the code you pull down off the web is covered by a Creative Commons license. And if you incorporate that into your main line of code, what you've written will now technically be under the Creative Commons license. So you have to be very careful about that, and you have to tell people who are coding about it to be careful about that. So if you have any thoughts on that.
I'd also just like to add, with software, so people have a sense of copyright versus patent. Your Cadillac is patent protection. Copyright is less protective, because the idea of copyright is to protect expression of a concept or an idea, but not the idea itself. The patent will protect the idea or the concept. So that's why if you want to stop somebody from doing some concept, you want to think patent. If you just want to be able to protect the way you implement some concept, that's where the copyright comes in. So just so you have a sense of on that scale of IP protection, where copyrights and patents fall.
Great, that sounds great. I think, why don't we jump to maybe a discussion of when and how to contact sort of tech transfer. I guess, Zev, at what point do you want to hear from your inventors? What are you looking for from them? And then at what point are you getting the law firms involved? Like, sort of at the very early stage of a concept, when do you want to get involved?
So what we like to say is early and often. You certainly want to do it before we give up rights, before you start publishing or presenting. But certainly we say that, if you're getting ready to put together a paper or a presentation, you've probably got a lot of the data and information together that we could use, so that would be a good time. But we've even had, faculty come to us very early at the concept stage to say, I want to repurpose a drug. I think it was an oncology drug. I want to use it for CF. And we can say, hey, we can actually do a patent search to see. You may not have seen anything in the publication realm, but we can see if there's actually been IP on there. So you can come to us very early, sometimes at the concept stage, and we can talk you through the types of data and the types of information. And as I like to say, we're not like the NIH, where you submit a disclosure to us and we say no, and you can't come back to us for 6 months, and you only get 2 tries. Ours is a very iterative and ongoing process. So you can come to us very early with concepts and questions, but certainly you want to come to us when you've got a fair amount of data or proof that there might be something there. Because at that point, you're going to want to start presenting it to other people, whether it be at conferences, putting information on your lab's website, or papers. Because as we'll talk about later, doing so can lose the ability to patent it. So the one thing I would suggest is that you come to us early, you come to us often, you keep good records and lab notebooks, not only of what you're doing, but who's doing what. Because one of the things we'll talk about later is who's actually an inventor on that. And unlike the publication realm, where there's all kinds of courtesies and general rules, it's actually a legal determination as to who is an inventor on a patent. So keeping good records. The other thing that will be important is when you do come to us, we're going to ask you what else you know. What do you know about the art as a whole and what other people are doing? Because we're going to use that as part of our analysis as to whether there's anything patentable there. When you disclose to us, we're actually looking for a couple things. First, we're looking to see if we actually have any rights, depending on who funded it, who you worked with, who else may have rights. We're looking at, is it potentially patentable? We're going to search that prior art, and so the more you can tell us, the better. And then we're going to try to do a business case analysis to say, is it worth patenting? And the earlier you can come to us and the more data you can bring to us in whatever form you have, the easier it is for us to look at all that and try to get back to you, not only with, what do we think about patentability, what do we think about commercial prospects, but who might you partner with or who might you avoid if this is something, you really want to take forward on your own? Because there's actually 2 different, situations. Some people are very tuned to, I want to start a company, I want a license. Others are just trying to figure out who else can they partner with to further develop this. We can get that early IP and a stake in the ground, and then partner with other people who can bring in expertise and funding to help further develop it. But almost all your academic offices will have an online form or some type of form where it will ask you a series of questions. Who's involved? Who funded it? What do you think that you've invented? What are you trying to solve? And then how did you solve it? You know, patents are all about identifying a problem and identifying a solution. I like to talk about, and we can get into this later, about, you know, a lot of times science is better defining the question, and that's harder to patent. You know, there's a whole question about diagnostics. It's really about, have you started defining a solution? And once we start getting data about what that solution might look like, coming to us can help do that analysis, and then bring in people like Joe and Scott or other firms to help us do that. And then when necessary, start really crafting patents that can protect you going forward, because the patenting process can, again, help bring in other partners in the future to help bring this to market.
Joe, we have a question for the audience, if I might.
Sure.
The question is, how does a prophetic patent fit in with being in possession of the invention?
That's a good question. You know, it's an interesting situation. I think if you can, I've seen situations where prophetic patents, I'll say prophetic examples rather than prophetic patents. So what will happen is, generally speaking, you know, you write up the application and you've got the conception of what you think is going to happen. And so you can write a prophetic example. Now, what I usually do when I write them, I don't necessarily, you can label them as a prophetic example. Sometimes you just write it in sort of present tense, so it doesn't sound like you did it. It sounds like you do it. That's another option. But there are cases where courts will rely on a prophetic example and say that the written description requirement was met. Especially, I'll say it this way, if your guess is correct. If you can say, well, we disclosed the method of how to, you know, make and use this or practice the method or whatever, and then it turns out we were right. So maybe you can look back and say, all right, well, the prophetic example covered us on that. So I don't know, you know, Zev or Scott, you guys may completely disagree with that, or if you have any thoughts on it.
Well, I would say I don't usually come across terms like prophetic. Mostly it's, are we meeting our enabling requirement, making sure that we are showing how to make and use the invention in accordance with the Title 35 of the Patent Act. So I'm always emphasizing to the inventors that we need to be able to show how to make and use something so that somebody skilled in the art isn't guessing. I always try to say, if somebody has to guess as to one step or one aspect, you haven't met your duty of the enabling requirement. So I always, and as you say, I try to use the present verb, not the future tense, to give the examiner the sense that we do possess the invention. It's not something we're just, you know, guessing at.
Right.
The one thing I won't get too much into the details of meeting the various regulatory questions, but you have to be careful that if you file something that is fairly prophetic in nature and you aren't following on to get the data, particularly in that provisional period, that IP can come bite you later. You know, it may poison the ability to get better claims later when you actually have data. You know, particularly if you file it and it gets published before you've actually gone to further prove it and develop it, and depending on how that veers, it could hurt you. So you have to be a little careful about, you know, whatever you call it, how much you've got and how sure you are in the direction you're going.
Maybe we can take a bit of an aside here and discuss sort of the flow of patents. And you had mentioned, Zev, the provisional patent. So how this process usually goes is, if you have an idea that's an early stage idea, you can file what's called a provisional patent application, and the filing fees for that are relatively low. And if you want to add additional subject matter to that, you know, you have a year in which to do that. And at the end of the year, from that initial filing date, you have to decide whether you're going to file like a U.S. utility application or an international application, usually a PCT application, let's say. Another thing that you consider doing in this situation, I think, Zev, that you had mentioned, where you're coming up with a concept and you need to add some supporting examples, say some supporting evidence. We like to do what's called a rolling provisional strategy, where you file the first one. And you don't necessarily have to call it prophetic, but it's sort of your highly educated estimation of what's going to work. If it does work during that year, you can file a second provisional, third provisional, fourth, and then at the end of the year, when you file your U.S. utility and/or PCT again, and we'll talk about those later, you can wrap them all up into one application, and you will actually have. You may split the priority a bit, but you'll basically have priority back to the initial one for the most part. So that's a good strategy to use. And I don't know, Zev, if that's something that from the tech transfer offices, if that's something you commonly do or something you think about.
So we don't as often do rolling, and the reason why, and one of my big soapboxes I'll jump on for about 2 minutes is, when I talk about reaching out to us early and often, is often we file provisionals because I get a call from Dr. Jones who says, hey, I'm presenting at a national meeting tomorrow, or my grad student is presenting at a national meeting or has a paper coming out. And this is my favorite, and I've heard you can file a patent application in a day. So often these are very early sets of data that they really want to get out in front of their professional societies very early. And so while it's not completely prophetic, it's not completely fleshed out. And in those cases, we will often file a provisional so that we can protect ourselves before they go present the next day. So the first thing on my soapbox I will say is, yes, we can file a patent app. Well, we can't. I would call Scott or Joe or someone else and say, you have 12 hours. Can you file a patent application? And we joked when we set this up the other day. I've been doing this long enough that I remember when they had to be physically presented to a post office to be time dated, and I actually had attorneys in California because it bought me extra hours in the day. But if you are presenting tomorrow, please call us. We will do as much work as we can. But as I like to say, if I called Dr. Jones and said, can you write a grant application in a day? He or she technically can, but it's not going to be their best work. So if you want us to do our best work for you, covering it as broadly as possible, come to us as early as you can to give us time to get back, work back and forth with you to make sure we've captured your invention and we can cover it as broadly as possible. But going back, jumping off my soapbox, what we are usually going to do at that point is file a provisional, because that does give us a year to continue to add more, data and to fully flesh it out. We may consider a rolling one. The downside of the rolling one is if there was a presentation in the interim, that's not going to work. If there hasn't been some kind of, public disclosure, a rolling one could work. But if we're doing it to beat those publication and paper deadlines, we usually have just that year, and then we're likely going to go into a PCT, sort of that holding phase, which allows us to pick which countries we want to go into.
Can I just add to Zev, what
Sure.
Zev was saying and Joe's, the idea of a rolling provisional, you might want to file several. Your audience should be aware that with the American Invents Act, we changed from a first to invent to a first to file. And what that means is it's basically who gets to the patent office first is going to be able to protect the patent. If you're in a hot area where there's a lot of development, even if somebody publishes something in your area, that alone could prevent you from getting your patent. So if you filed a provisional and you had some substantive development and you didn't file on this new stuff within the year, and somebody else just published it on that development, that might be rare, they could stop you from getting that patent, even though you filed the first provisional. So one of the things we're trying to counsel our clients is to really look as you develop, if there's really substantive development going along within the year, you may want to consider filing a second or third or fourth provisional to make sure that somebody else doesn't disclose this, and then that can become prior art to you if it wasn't disclosed in the very first provisional. So another thing to just be aware about.
Yes.
One thing that, I'm sorry, did you have something to add?
No, I was going to say to that point is when we start working with a PI, we will often tell them, okay, we filed a provisional, or even when we get further along, if you've got another paper coming out because you've advanced it, let us see that. Or if you've got another presentation, let us see if there's new data or new things we should cover. And we will often ask is, how hot is this area? You know, do you think that there are people, you know, that you might be competing with? You know, I remember siRNA, RNAi, CRISPR-Cas9, CAR-T, all of those where, you know, right, there are times when almost anything with those terms in it become very hot, and people are just filing right and left to try to beat what they know is a very crowded and competitive field.
Well, I think this might be a good time to jump in, and since we're talking about early filing and we're discussing about conferences and meetings and things like that, one thing to keep in mind for the audience, and there's a couple differences. Scott had mentioned the American Invents Act for the U.S. Under the old patent law, there was sort of an exception. So if someone had something on file and you could kind of swear behind the reference if you filed within a year or so. But now that's sort of gone. And the only way that you can, if there's an early disclosure of your invention, you can, if the inventor disclosed it, or someone who worked with the inventor disclosed it, or someone who derived their disclosure from the inventor, there's still sort of that 1 year leeway. The problem is, number one, a year's not that long. Number two is it can really knock out your ability to file internationally, and I think that's probably the biggest danger. We've been mentioning this PCT situation, so that's a patent cooperation treaty. So that's sort of a way to file one application and have the ability to go enter a lot of different regions and nations across the world. There's, I don't know, I'm not sure how many it is now, 200 some, maybe something like that.
153.
153. Okay. Yeah, so the problem comes, a lot of these countries, like I know Europe, well, Europe's not a country, but the region, a lot of the countries in Europe, China, things like that, require absolute novelty. That is to say that the application has to be filed before there's any disclosure whatsoever. Otherwise, you will lose your right to get an application. Get a patent on that subject matter. As I said, in the U.S., there's some exceptions, and they're more narrow than they used to be. So really contact your tech transfer office if you're thinking about going to a meeting or filing a grant or doing any kind of public disclosure. Well, the grant may or may not be a public disclosure, but I err on the side of caution on that one. So Scott or Zev, do you have any thoughts on that?
Well, I would like to emphasize to the audience too, if they're not familiar, the U.S. is very forgiving. As Joe mentioned, you have that year. If you do disclose or offer to sell, the U.S. is forgiving. It gives you a year within which to file. But most countries aren't that forgiving. They're absolute novelty, as Joe mentioned. So that's what you have to be aware of, and that's why you need to get to Zeb quickly, because you may be forfeiting foreign rights without even realizing it. So because the U.S. does give the year, but the other countries don't. So that's why you want to be aware. You want to protect all your rights, both U.S. and foreign, by getting to the tech transfer office early, so they can counsel you and get the things going, so that you don't jeopardize any rights without you even realizing it.
So one thing I will jump in on the foreign question, because this comes up in our office a lot, is that as an inventor, you have to understand that a patent only protects you in the country in which you filed it and had it issued. So if you want to be able to keep people in Germany, Japan, wherever from selling your product, we would need to file in each of those individual countries. And that's, we need to know that early, but we also will be wanting to make sure that we see a huge market for it in those, because the prices climb exponentially at that point. Really, when we start in the US, if we then start filing in Japan, we're paying our US attorneys to communicate with our Japanese firm, and you're paying someone in Japan who has a PhD in a relevant science and is an attorney to translate everything in this one. So the prices can become quite significant. It doesn't mean we don't do it, but we usually will only do it if we've got a licensing partner, someone else who's picking up those costs, because they can reach into hundreds of thousands of dollars, sometimes each year, for a large patent portfolio. So that is a consideration, but it is something you need to understand, that the protection is only there in the countries in which you have filed. And so one of the things we'll talk about, since we're talking life sciences, is where's the prevalence of that disease? Some diseases are much more prevalent in some areas than others, so that will be part of the determination on that filing strategy. And also, as we know, some countries are better at enforcing patents than others, and so sometimes that plays into it as well.
I think you've hit on a couple of the 3 points that I usually counsel clients on which country to enter or which region. You mentioned where is the disease prevalent, so where's the market, where's a big enough market to make it economically justified to expend the cost. Another thing to consider is where could they make it? So if you're talking biotech inventions, say, or even pharmaceuticals or whatever high tech, there's only relatively limited places that they could make it. So you want to try to get coverage in those countries where there's a market, and those countries where they could actually make what you're claiming. So that's sort of one thing to think of. That's one way to think about it. Maybe we can jump ahead to sort of what's the timeline. We've kind of touched on this, right? We mentioned the provisional patent application, and then how you have a 1 year to file either the U.S. utility and/or PCT, because you can file a PCT and then jump back into the U.S. at the end of the timeline. And so with that, the timeline for that is 30 months. So 30 months from your provisional filing date, you at the 1 year mark, you enter the U.S. You either file a U.S. utility or file a PCT. If you file a PCT, you get 18 more months. So that's totals of 30 months before you have to make the decision about what countries you want to file in. Now, as far as patent prosecution goes, with regard to the U.S., there are certain ways you can actually advance prosecution. I would say, normally speaking, in the biotech, I would say it usually takes about 2.5 to 3 years. Even sometimes it takes a year and a half, 2 years for the thing to get picked up to examine, frankly. And then, probably a year or two more prosecution. Now, there's a certain ways you can speed that up. Maybe Scott, maybe you can speak to a couple different ways, to advance prosecution.
Sure. So as Joe mentioned, typically, if you don't do any advancement, a patent application will be picked up in the order it's filed. So it just gets in line. And typically, the course estimate could be 2.5 years before they pick it up in some cases. It all depends on the workload of the technology group. So the idea is, how can I speed that up? Keeping in mind that if there's an inordinate amount of delay, the patent office will adjust the term of your patent if they feel they delayed too much. So they'll add so many days to the patent term if they delay on their end. You have 20 years max. So when you prosecute, you're eating into that 20 years. You want to try to keep the prosecution short, but that may be out of your hands. So what can you do? In U.S. patent practice, you can file what they call petitions to make special. And that literally will pull something out of the line and get it to the examiner early. And some of them cost, some of them don't. If you have an inventor that's 65 years of age, that doesn't cost. You can get it pulled out of line. Even COVID, well, there's one for green technology. There's some for infringement, but we counsel clients to be careful about that, because that could also be discoverable in a litigation. But there are ways to get it out of the line by petitions to make special. The best way, the most guaranteed way to do it is to file what they call a track 1 or a prioritized examination. But that costs for a small entity could be $2,000 plus a $70 processing fee. But that will get the application out of line to the examiner early in the process. And that really is the longest wait in the prosecution. It's waiting for the examiner to pick it up. Once the examiner picks it up, office actions and examination will occur, and then you'll have the dialogue with the examiner. So that's really what you want to speed up, is getting the examiner to pick up that case early. So you can file a prioritized examination, but that, like I said, costs. The other thing that you can do, there's another free aspect called the first action pilot program, interview program, will allow you that once the examiner picks up the case, he or she will accelerate it if you're willing to do an interview up front. But it doesn't accelerate pulling it out of line. But it is some other avenue you can take. You can request that at no cost. But you have to also keep in mind both the first office action interview program and the prioritized examination has requirements on the claims. You can't have more than 4 independent claims or more than a total of 20 claims for the first office action interview program. Can't have more than 30 claims for the prioritized examination. But with that said, those are probably the main ways to get your application in front of the examiner quickly. So the other thing that you can keep in mind is, even though the examination in the US, even without any of these accelerated examinations, you just don't know, you have to wait your turn. The PCT, if you file a PCT application, for some reason they are very organized. And you can probably count on getting a first, what they call a written opinion, international search report, a written opinion within 6 to 8 months of filing. That's pretty, you can rely on that. So that's another thing you can weigh. If you're really looking to get some kind of patentability determination early, if that's critical for you and you don't want to pay the $2,000 for the prioritized examination, you could file the PCT route and then really get that first examination. And the other good thing about the PCT written opinion and international search report is you're not obligated to respond to that. Whereas if you get an examination in the US, you will have to respond to keep the application from going abandoned. And under the prioritized examination route, everything's accelerated. So you're going to have to respond quickly to the action and maintain that through the prosecution, or else it'll fall back into the normal patent examination process. One thing that's an aside that I would like to keep your audience in mind, for those in the medical device field, one other thing to keep in mind is, unlike processes or systems or formulations, is that if you make housings or containers for your device, you can also take advantage of design patents for any ornamental or aesthetic features. And that can be a very important layer of patent protection separate from utility patent protection. So keep that in mind for you medical device people, that if there's some unique or cool looking housing that you are developing, you could probably even protect that as a separate invention. So keep that in mind also. There is under a prioritized examination, a COVID-19 prioritized examination where they'll waive the fee. So if you have an invention directed to COVID-19, you won't have to pay the $2,000 or the $70 processing fee. That's waived. So if you
for
have
the track one.
For the track one, so keep that in mind. That's something they've recently come out with.
I think another good point about, you'd mentioned the search report and the written opinion you can get in a PCT relatively quickly. That's another way to advance prosecution, internationally, say, because there's this patent prosecution highway. So that's the U.S. and some other countries have gotten together, and they will share and give some deference to, if you, for example, get a notice of allowability of certain claims, you can sort of tailor those claims in other jurisdictions and say, look, we got an allowance, we received a notice of allowance in the US, our claims look very similar here in Europe or in China, Japan, whatever. And there's obviously issues because certain methods of treatment are not you have to claim it in a special way in Europe and in China, et cetera. But it can advance prosecution if you make use of the patent prosecution highway. And there's not really a cost associated with that. At least in the US, I know there's no cost, no filing fee costs associated with it. So that's something to keep in mind too.
Yeah, and thanks, Joe, for reminding me about that. With the patent prosecution highway, like Joe said, you're piggybacking off the efforts of another patent office. So if they found something allowable, you'd like to be able to present that to the other patent office and say, look, this patent office found it patentable. Will you do the same? They're not obligated to. They can still do their own searching, but they could consider persuasive and also allow based on the same grounds. You must be able, you must keep aware though, once the other office picks up the case for examination, PPH is no longer available. So it has to be done early in the process so that they haven't already started their examination process overseas.
Mm-hmm. Is that something that you get a chance to make use of at all?
We don't very often, and I'll tell you why. Academia, unlike industry, is often so early in the science that we're not necessarily always in a hurry to get claims because the claims may shift a little bit as we continue developing and de-risking. I mean, obviously you can file follow-on continuations in part, but we're often, unless we have an immediate commercial need, if it's still very somewhat exploratory, we don't usually try to accelerate. If it is something where we've licensed, or again, it's a very competitive area, or we're further along in the science, we may. So it's really a business case question. And one of the things I like to throw out to people is, you know, when you start talking about 2.5 years for this, 3 years for this, 5 years for this, sometimes I have scientists say, well, Zev, I may not be at CHOP in 5 years. I'm not even going to bother to start. And I will say academia, in this case, has a huge benefit over industry. Industry, when you invent something, you might get a plaque, you might get some money, I don't know. But in academia, there are certain laws and rules where we must share a portion with you if we generate anything, and that's even after you leave the institution. The amount of time that my accountants at various institutions have spent hunting down people who used to work there to send them checks is incredible. So the other thing is not only do you tell us about your invention, but if you leave, tell us where you're going. Because if we license something you disclose to us 5 years later, we're still going to try to send you money. You're still going to get the same percentage you would have gotten if you were at CHOP. So even though this process can take a long time, it shouldn't discourage you because the science likely takes a long time as well. So yeah, there are some times that we'll try to speed things up depending on, you know, I've had somewhere we were in litigation where it was very helpful. But if it's something we're still trying to license and we know it's a very active field as far as a lot of change, we may not speed it up as much.
Right. I think this brings us maybe to, you mentioned quite a long time. So I think, Scott, you had mentioned patent lifetime is 20 years from the date of filing. Not the provisional doesn't count against you, actually. It's the date of either filing the PCT or the U.S. utility. You get 20 years from that. And there's maintenance fees that you have to pay at 3.5, 7.5, and 11.5 years. So that's something to keep in mind too. I wanted to jump. We were going to get into some issues with regard to patentable subject matter. So this has to do with, in the context of biotech, and I think if we have time, Scott's going to mention about medical devices and software and things. So there's certain things that are patentable, and compositions of matter, processes, machines, things like that. In the U.S., you can get methods of treatment and all of that. But there are exceptions to that were made by they call judicial exceptions, right? So laws of nature, natural products actually are an exception, and abstract ideas are an exception as well. And so, as you can imagine, that comes up quite a bit in the area of medical treatment, and diagnostics can be a real issue. And so, the way the courts and I'll actually, the courts look at it a little bit differently. The PTO, I'll talk about the PTO, I think. So what the PTO does is they'll look at the claims and they'll say, okay, is this directed to one of these to a statutory category? It's directed to a process, machine, composition of matter, something like that, or is it directed to, quote, you know, one of these exceptions, an abstract idea, some sort of mathematical equation, something like that, or natural phenomenon, or law of nature, or you know, natural product. And this was really sort of threw a wrinkle into essentially software patenting, and it's really hurt diagnostic methods recently. And treatment methods seem to be getting a little bit better, and I'll mention why. So based on some case law, the way the patent office now looks at it is they look at whether there's a practical application. So what that means is, like for a computer, does it improve the function of the computer? In the context of biotech, is it a treatment method? And I'll give you an example. So there was a case where the claims were directed to treatment with 6 autoimmune disorders with 6 thiopurine drugs, and basically the claims were directed to measuring the metabolites and making a decision about whether to continue with the treatment. And those were found to be directed to unpatentable subject matter because it was sort of an abstract kind of idea. There was no real meat on that as far as treatment. And then, but more recently, there was a case where it was in the iloperidone. So this is a treatment for, I think, schizophrenia. And the claim was directed to genotyping the patient first, and then determining, given the genotype of a CYP2B, CYP2D, I think, metabolizer of the patient, the claim set forth the treatment regimen as far as dosage regimen and that the patient should receive based on their genotype, and that was held to be directed at patentable subject matter because it was a practical application. So I think that's kind of the way that courts are looking at these cases in the context of sort of medical treatment. Now, in the context of, like, say, a vaccine or something like that, where oftentimes, obviously, a vaccine, speaking of COVID, a vaccine is going to be taking a short sort of protein sequence out of your target that will raise raise an immune response to it. So that almost by definition is going to be a natural product, right? You're going to take a chunk out of the natural protein and hopefully induce an immune response. So how are you going to claim something like that in the face of that being a natural product? And I think one way to get that into a practical application is to have it in the context of a composition of matter whereby there are other non-naturally occurring elements in the claim, in the composition. Now that can be either, the peptide sequence itself of the antigen or the vaccine, you call it that, in the context of other amino acids that are on either side of it or something like that, or that can induce a larger immune response, something like that, or claiming the composition, things like that. Some way to get it into a practical context, a practical application. Now, Scott, I think this comes up in software quite a bit, and maybe you have some examples about it in that context.
Well, I think, yeah, the same idea is just because it has a computer, it doesn't make it a patentable subject matter. And I think Zev hit it right on the head early in this program, where he said we must think about technology problems and technology solutions. In computer software or computer implemented inventions, you have to be able to show an improvement, some kind of problem out there, and there's a solution to it. A recent Federal Circuit Court case that just came out in April had a patent that was directed to being able to distinguish between atrial fibrillation and atrial flutter. And they upheld the patent because they showed an advancement in the technology here. But it involved the computer, involved software. But you have to be able to provide a technology problem, identify the problems, and show that you have a solution. Otherwise, the patent office will, and the courts will be treating these things as just an abstract idea, which is hard for people to understand, because we all know these are concrete things. A computer's concrete, so is a software solution. But yet that is what the case law that you mentioned earlier, Joe, has determined. It has to be able to show a technology solution. You want to focus on any new hardware. You want to avoid steps that a computer normally does. Uploading, storing, analyzing, those kind of steps are going to be considered just abstract because that's what a computer does. Yet it's difficult to ignore those. But you want to put any type of filtering or something unique that you had to do that people haven't been able to solve for you to make this solution occur. And the thing that I think, go ahead, Jim.
Oh, no, I was going to say Zev had wanted to jump in if he's seen that these kind of issues are.
You know, one of the first companies I ran was a software company, and we actually had issued patents on the software, and you know, that has changed so much, and it's very much a moving target. Same thing with diagnostics. It's becoming more difficult in many cases.
And
I think go ahead, Scott.
I just wanted to say, one of the things, Congress has to act in this area, because what's happening, the Patent Office feels more and more obligated to do something, and it came out with guidelines in January of 2019, and that actually helped more computer applications get through, only to get to the courts, and the courts say, well, that might be nice, but we're not going to abide by those. Those are just guidelines, and they will invalidate the patent. So this is not a good situation, because the Patent Office and the courts are not on the same page. Congress needs to come up with a unified approach so that the Patent Office, the way it gets examined, will be respected by the federal courts if the patent gets asserted or attacked.
Great. I just got to notice that I think we're getting pretty close to our time. So maybe if anybody has final thoughts, maybe Zev, if you want to, do you have anything final? Or
like I said, reach out early and often. If you don't know, ask, and do it before the last minute.
I would ditto to what Zev said. Early. If you're not with a company, if you're a sole inventor, seek out the patent attorney, patent agent. Do meet with them before you take one step outside. It'll make all the difference in the world. Act early. I 100% agree with Zev.
Great. Well, I wanted to thank everybody for coming and joining the meeting today. I think we had a pretty good crowd, and it was really enjoyable. So thanks so much.
Thanks,
Yes, and on
everyone.
behalf of BioStrategy Partners, thank you to our panelists. Really great information here today. We really do appreciate your time. And once again, thank you to our sponsors.
Thanks, everybody.